Good afternoon again, everybody, and thank you for joining us today for our online talk. We'll be starting in a while. Thanks for those of you who have joined early, and we are still seeing a few of our attendees joining in as we go on. While we wait for the session to begin, which will begin very soon, we would like to share a short video about our firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody, and thank you for joining us for today's online talk. It is called Sexual Harassment Complaints in the Workplace, Managing Risk, Compliance, and Tribunal Proceedings. My name is Joseph, and I will be your moderator for today. Before we begin, allow me to briefly introduce our firm and the work that we do. Ma Weng Kwai & Associates is a mid-sized law firm founded in 1985 by Datuk Ma Weng Kwai. Our able team today consists of 35 lawyers and a support team of 29, including my two very wonderful and skillful colleagues we have here today. Following his retirement from the Court of Appeal bench in 2015, Datuk Ma is now a consultant with the firm. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment and industrial relations team, of whom our speakers are from today, and a department focusing on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWK online talk series. We have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objectives of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. Should you require specific legal advice in relation to your matter, please feel free to contact us for a complimentary legal consultation. Further details will be provided at the end of this talk. Our first speaker is Sonia Mohan. She's an associate in our Dispute Resolution and Employment Law and Industrial Relations Department. She has a Bachelor of Laws from Multimedia University, admitted to the bar in January 2022. Her areas of practice include general litigation, insurance accident claims, corporate and construction disputes, employment matters, criminal and family law, contractual disputes, as well as probate and administration. Our second speaker is Kirthika Padamanapan. Is also an associate in our Dispute Resolution Department. She graduated with a first-class honours in laws from the University of Leeds, United Kingdom, called to the English Bar in 2021 and admitted to the High Court of Malaya in 2023. Her areas of practice include family and citizenship matters, employment law, and criminal defence. All right, I will now pass the time to my colleague, Ms. Sonia Mohan. Over to you, Sonia.
Thank you, Joseph. Hello, everyone. Good afternoon. I will be your first speaker for today. I will be covering the first two topics, and the third and fourth will be followed by my colleague, Kirthika. So, what constitutes to sexual harassment? Section 2 of the Employment Act 55 states that any unwanted conduct of a sexual nature, whether verbal, non-verbal, visual, gestural, or physical, directed at a person which is offensive or humiliating or is a threat to his well-being arising out of and in the course of his employment. According to Section 2 of the Anti-Sexual Harassment Act 2020, any unwanted conduct of a sexual nature in any form, whether verbal, non-verbal, visual, gestural, or physical, directed at a person which is reasonably offensive or humiliating or is a threat to his well-being. According to the 1999 Code of Conduct, any unwanted conduct of a sexual nature has the effect of verbal, non-verbal, visual, psychological, or physical harassment that might, on reasonable grounds, be perceived by the recipient as placing a condition of a sexual nature on her or his employment, or that might, on reasonable grounds, be perceived by the recipient as an offense or humiliation or a threat to his or her well-being, but has no direct link to her or his employment. Sexual harassment, according to the 1999 Code of Conduct. Sexual harassment may be divided into two categories. One would be sexual coercion is sexual harassment that results in some direct consequence to the victim's employment. The second one would be sexual annoyance. The second type of sexual harassment is sexually related conduct that is offensive, hostile, or intimidating to the recipient, but nonetheless has no direct link to any job benefit. There are a few types of sexual harassment according to the EA and the Anti-Sexual Harassment Act. We have verbal harassment, such as offensive or suggestive remarks, comments, jokes, jesting, kidding, sounds, questioning. Those are all verbal harassment. Non-verbal harassment would be leering or oogling with suggestive overtones, licking lips, or holding or eating food provocatively, hand signal or sign language denoting sexual activity, persistent flirting, all would fall under non-verbal. Visual harassment would be showing pornographic material, drawing sex-based sketches, or writing sex-based letters, sexual exposure. Psychological harassment would be repeated unwanted social invitations, relentless proposals for dates of physical intimacy, and lastly, we have physical harassment, which would be inappropriate touching, patting, pinching, stroking, brushing up against the body, hugging, kissing, or fondling. Now, employer obligations and legal compliance. The employer's foundational duty. Regardless of the contractual or statutory obligation, employers must provide a safe and conducive working environment. Employers must respect an employee's person, dignity, and esteem, and failure to do so amounts to a breach or repudiation of the employment contract. In Abu Osman versus Maleva Corporation Berhad, the claimant had filed a claim at the Industrial Court for constructive dismissal following his demotion by the company due to allegations of sexual harassment, including physical molesting female staff by touching part of their bodies, suggestions and verbal advances, and suggestions of a lewd and sexual nature, threatening to transfer or dismiss staff if not cooperative sexually or socially. In this case, the claim was struck off because there was no evidence that was tendered by the claimant, but the court noted the fundamental duty owed by employers to their employees. The principle that was found in this case would be an employer owes a contractual obligation to his employees, female or otherwise, to ensure that he provides a safe and conducive working environment in which they can function. In the context of the problem of sexual harassment in the workplace, it cannot be emphasized strongly enough that the employer would be in breach of a fundamental and essential term of the contracts of employment existing between the employer and his employees if he failed to take steps to put a stop to acts of sexual harassment which had been duly brought to his attention. According to the Occupational Safety and Health Act 1994, the Act mandates employers to ensure the safety, health, and welfare of all employees. The objects of this Act would be to promote an occupational environment for persons at work which is adapted to their psychological needs. According to the Employment Act 55, the Employment Amendment Act 12 had introduced a fundamental change with a clear statutory definition of sexual harassment. Section 80 of the imposes an express, unqualified obligation on employers to inquire into sexual harassment complaints. Section 81H of the EA provides for conspicuous notice, employers are legally required to exhibit a notice to raise awareness on sexual harassment. Next, we move on to managing complaints and workplace investigation. When a complaint is received, employers must act promptly and fairly. The complaint itself is sufficient to trigger the employer's Section 81 obligation to investigate. The standard of proof in domestic inquiries, disciplinary proceedings, and industrial court cases apply the civil standard of proof, which is the balance of probabilities. Employers do not need to meet the higher criminal standard of beyond reasonable doubt. The test is whether the employer had cogent and rational grounds upon which to reasonably believe the misconduct had occurred. The myth of the police report. A police report is not required for an employer to launch an internal investigation. Believing a police report is necessary causes harm by delaying investigations and creating barriers for complainants. An employee acquitted in a criminal court can still be lawfully dismissed based on the employer's internal inquiry. Silence is not acquiescence. Harry Wong Wei Chen and Petroleum National Berhad, 2021. In this case, the claimant had been employed by the company as a staff in the Middle East and Central Asia Basin Department. He had also been placed as the project manager under the project Petronas and NIOC. This is known as the Iran project, whereby he had been a team member. The company received a complaint from the complainant in relation to a series of actions allegedly committed by the claimant, wherein he was alleged to have committed sexual and/or workplace harassment against her. An investigation was commenced and the claimant was suspended from duties after being served a show cause letter. Subsequently, a domestic inquiry had been convened against him, at the conclusion of which he was found guilty of all the charges preferred against him and dismissed from service due to the severity of the misconduct. The claimant appealed to no avail. The claimant that his sale had been carried out without just cause and excuse. The industrial court then dismissed the claimant's claim and held that even though the complainant had remained silent after the alleged incidents and that it had not in any way affected her attitude or performance in continuing to work with the team in Tehran, in cases of sexual harassment, silence or passivity does not necessarily mean acquiescence. The complainant, being in a small close-knit project team in Tehran, may not have wanted to rock the boat and cause animosity, not to say the least, making her life miserable at work whilst being in a foreign country, but at all times she related incidents to her friends, as evidenced from the WhatsApp messages produced by the company. Those messages clearly showed that the complainant did not welcome the claimant's untoward behavior. So, in this case, the court found that silence or passivity in sexual harassment cases does not necessarily mean the victim consented to the conduct. In most cases involving sexual harassment, the victim would remain silent, hoping to weather the storm until they could not tolerate it any further. Delays in reporting an incident of sexual harassment are not fatal to complainant's case. In Kamarul Baharin Kamaruddin versus Composites Technology Research Malaysia Sendirian Berhad 2025, where the court held a delay of 2 weeks in reporting was not fatal, as the court considered the complainant's reasons such as fear and uncertainty. Is corroboration of evidence required? While evidence enhances credibility, it is not an absolute requirement in establishing sexual harassment. In Muhammad Rizwan Abdul Razak versus Asma Haji Muhammad Noor 2016, the court held that there is no hard and fast rule that in a tort of sexual harassment case, there must be corroboration. Though like in any civil case, the rule of evidence must be stringently upheld. Impact over intention. In Junaidi Qasim versus Malayan Banking Berhad, the claimant served with the respondent as a customer experience assistant at one of the bank's branches. There were 5 charges of sexual harassment which were leveled against the claimant, namely for taking photos of the complainant covertly on several occasions, without her knowledge, which contained an unwelcome intention towards her, for repeatedly harassing the complainant by asking her to join him for a meal, including sending a WhatsApp message asking her to join him for lunch or a candlelit dinner, despite the complainant declining his invitations in the past, texting the complainant inappropriate and suggestive messages, which made her uncomfortable, including one incident where the claimant had taken a video of the complainant and sent the same to her with a suggestive comment. On a later date, the claimant informed the complainant that he had intended to post the pictures and videos taken of her on his social media account. Taking a photo of the complainant without her consent and knowledge, which focused on her backside, and sending the same to the complainant with the comment, the claimant found the picture to be inappropriate and requested for the claimant to delete it, but the claimant responded by saying that his handphone was old and could not delete the photo. The claimant then said he would purchase a software that could remove the clothing from her picture, and making a remark to the complainant, "Tak apalah, tak nak tolong, nanti saya buat gam sendiri," when he approached her to borrow glue. In response, the complainant replied, "Buatlah." The claimant then replied with the suggestive remark, "Bukan gam yang ini, gam lain." The bank's human resource disciplinary committee had found the claimant guilty of the allegations. The bank then proceeded to dismiss the claimant. The claimant's appeal against the bank's decision was unsuccessful. Claimant claimed unfair dismissal, and the court dismissed his claim. While the claimant admitted to committing the actions as per the charges, he objected that the actions constituted as a sexual harassment. The claimant's action in the first charge was clearly amounted to sexual harassment. Any reasonable woman would not want any man, let alone a stranger with no intimate relationship with her, to take her photos secretly or discreetly. Such an action clearly amounted to an intrusion of the complainant's privacy, since there was no consent given by the complainant, which amounted to sexual harassment. In David Chiu Yu Lin, the claimant was dismissed over 2 allegations of sexual harassment. Court relied on the twofold test of proving sexual harassment laid down in the book Sexual Harassment at the Workplace in Malaysia, in finding that the claimant had sexually harassed the complainants and as such dismissed his claim. The first limb of the test is objective and the second limb is subjective as summarized below. Would a hypothetical reasonable person feel that the complainant's reaction to the behavior was understandable in the circumstances? Factors such as the age of the complainant, their race or ethnicity and disability they may have, the context in which the harassment occurred, and the nature of the relationship between the parties could all be taken into account. Secondly, the claimant must show that they have been adversely affected by the behavior. Sexual harassment in the workplace is essentially a subjective concept where it is up for each individual to decide what does and what does not offend them. Ensuring due process for the accused. A fair domestic inquiry requires observing natural justice and a balanced standard. Charges must be clear, precise, and include exact times, dates, and the specific conduct. The accused must have proper opportunity to respond and challenge the evidence in front of an impartial panel. Dangers of deficient investigation, vague charges, and failing to verify evidence, for example, ignoring footage or failing to call material witnesses, can lead to unfair dismissal claims. If an employer dismisses an employee without a fair process, the industrial court may find the dismissal without just cause and excuse. With that, I end my part of the talk. I will pass the floor to my colleague, Kirthika, for the next section. Thank you.
Thank you, Sonia, for that first part of the talk. As informed, I will be addressing the last 2 points of today's talk, which is policies, procedures, and risk management, as well as tribunal claims and employer liability. So, I think the first thing every employer asks when it comes to claim of sexual harassment by any one of the employees, the question that comes is then, what happens before that, right? How do I prevent or how do I ensure that my workplace is safe, that my employees feel comfortable enough to come and disclose to me what has happened to them? The first thing that forms the very base of any good defense is a well-drafted and well-written policy, which would then be able to protect an employer. So how this would work is the employer would prepare a specific sexual harassment policy. This needs to be then communicated clearly to all your employees, whether this is by way of a company-wide email, or if, for example, you have new employees joining your company, you can then get them to sign off. They have or acknowledge that they have read the sexual harassment policy. Ensure that if you have HR personnel in your company, to ensure that they go through regular trainings so that they are aware of and are experienced in dealing with sexual harassment complaints and how to deal with them in a very delicate manner, because they are quite different from other complaints that HR may ordinarily receive. So all of this would then ensure that the company is well protected in the event of a claim of constructive dismissal from an employee who was sexually harassed, or a claim for unfair dismissal from the alleged harassed. So in the case of Ridwan Yahya and Asia X Berhad, this case is actually very interesting because the claimant served as a purser, which is basically, from my understanding, it's essentially like a head steward of an aircraft. And the claimant was issued with a notice to show cause, basically, because there were various allegations against him, including sexual harassment. And upon receiving the notice, the claimant responded basically denying the allegations and saying that he had just made these jokes in a very light-hearted manner and that it was just banter amongst. Interestingly, in this case, there was no domestic inquiry conducted by the company. And despite that, the industrial court still dismissed the claimant's claim for unfair dismissal because the industrial court held that there was a very clear company policy which precisely showed that the company was very intolerant towards sexual harassment, and it classified sexual misconduct or sexual molestation as a major misconduct under item 14 of its disciplinary policy. And this disciplinary policy had been circulated to all employees, which showed that the claimant in this case was aware of that policy, and despite that, proceeded to violate the policy. So because of that, the industrial court upheld the company's decision to dismiss him and dismiss the claimant's claim for unfair dismissal. Another thing to note is, I think Sonia covered this a bit early on in the talk as well, is that employees must take every complaint seriously, but at the same time, they must also be fair and investigate every complaint fairly to ensure that any allegations, if falsely provided, are thoroughly investigated. And what's interesting to note is that the court will also look at unsubstantiated allegations to see if they are motivated by genuine misconduct or alternative reasons. So in the case of Aspirenex, Sendirian Berhad, and Nirmalina Amaldas, this is actually a case that was a civil claim. It was a civil claim for the tort of harassment, amongst others. And what happened here, plaintiff was the company, and they filed a claim against the defendant, who was a former employee of the company, for defamation, intimidation, and extortion, harassment, and unlawful interference with trade. The civil court here allowed the plaintiff's claim against the defendant in respect of the tort of harassment. And why they did that is essentially the defendant here had sent a few emails to the plaintiff's director, basically messages that had gone on between the plaintiff's director and the defendant, and basically threatened to expose all of this on various social media platforms, and then to inform his wife, and eventually did end up going on to CC his wife in an email. She sent various emails to the Ministry of Human Resources as well as SSM, which is the Suruhanjaya Syarikat Malaysia. So what's interesting here is that the court looked at the evidence in totality. The court held that prior to the defendant's dismissal here, she did not raise any complaint with the plaintiff company, and only after being terminated did she then send all these emails and make numerous monetary demands against the director. And because of the way she essentially continually persisted in her emails, despite there being an injunction to stop her from circulating such information, the court did find that her behavior amounted to harassment and essentially allowed the plaintiff's claim in part. So this essentially reaffirms the previous principle that I was talking about in the previous slide, which is that the company needs to be very objective and look at all the evidence indeed. Upon receiving a sexual harassment complaint, it is not just sufficient to take the statement. It is also very important to also go into and investigate the point of view, because this is very important. So when it comes to complicity in terms of management complicity, the main risk that we see companies facing on a day-to-day basis is constructive dismissal liability. And what we mean is this. Essentially, when a company receives a complaint for sexual harassment, and if that complaint is not thoroughly investigated or is not taken seriously, an employee could then use that potentially as a basis to file to deem themselves constructive dismissal, and the High Court here upheld the decision of the Industrial Court. What had happened was the claimant here had filed a complaint against an alleged sexual harasser, and there were 7 such incidents that were reported to the company. And what happened was she had actually reported it to 2 separate people. One was Desmond Yap, who was the senior manager operations of the company, as well as the executive director, but neither of them took any actions against her complaint, in respect of her complaint against the alleged harasser. So in this case, the court held that because the company completely failed to investigate the complaint, the company failed to separate parties. And in this case, what they mean is when there are allegations of sexual harassment, usually what is done is that the alleged sexual harasser is transferred, or basically the no longer has to work with the alleged sexual harassment. This wasn't done in this case. The company did not conduct any internal inquiries or discipline the harasser. And because they failed to do this, it breaches the implied duty to provide a safe environment. And this is what Sonia talked about earlier in respect of the fact that regardless of any statutory obligations, at the very base of every employment contract, every employer has an implied duty, regardless of whether it's expressly provided for in their contract, to provide their employees with a safe working environment. And because in this case, Siddharth Berhad did not do that, the employee was well within her rights to deem herself constructively dismissed. So in addition to constructive dismissal claims from the perspective of the complainant, they can also file a claim in the civil courts under the tort of sexual harassment. Now, prior to 2016, there was no such recognized category of the tort of sexual harassment. And in this case, Muhammad Rizwan Abdul Razak and Asma Haj Muhammad Noor, the federal court imported the tort of sexual harassment into Malaysian law through judicial activism. And what this means is basically the court recognized and imparted from foreign jurisdictions and recognized that there was this idea of the tort of sexual harassment. And basically what that does is it now allows victims to directly sue their perpetrators in civil courts for tort damages. And what's important to note here is that whilst in the case of Muhammad Rizwan, the company wasn't sued in any capacity, employers could also potentially be named as parties in the complainants or the victims' claims. And in the event that there is complicity, the complicity we talked about earlier, which is failure to conduct the proper investigations, failure to do due diligence, failure to conduct domestic inquiries, they could also potentially face simultaneous liability if they allow the harassment to continue. I'll now move on to my next part of the talk, which is tribunal claims and employer liability. In 2022, the Anti-Sexual Harassment Act was basically enacted, and ASHA is interesting because it represents a very fundamental departure from the traditional Employment Act framework because it applies to any person and reaches beyond the employer-employee relationship. And what we mean by this is that essentially, anyone who has been sexually harassed and they're based in Malaysia and the sexual harassment has occurred in Malaysia, they can file a complaint at TAGS, which is the Tribunal for Anti-Sexual Harassment. It's referred to colloquially as TAGS. And this is interesting because it adds another front for employers to face liability. The front one, which is the claim for constructive dismissal alleged by the victim, a claim for unfair dismissal by the alleged harasser, a claim for civil action in tort for the tort of sexual harassment, or a claim by the employee in TAGS. And although the claim in TAGS is usually against the alleged perpetrator and not against the company. So when we look at TAGS, it provides an alternative channel to the civil courts for victims. Because what's important to note is that when it comes to civil courts, it's often a very lengthy process, which is quite expensive in terms of individual claimants being able to afford it. And it usually takes a very long time for claims to settle. So when TAGS was set up, key objectives included being able to handle complaints expeditiously in a simple manner and at minimum cost. So TAGS essentially can hear any sexual harassment complaints for incidents that occurred on or after March 2024, which is basically when the Act came into force. The complaints are subject to the Limitation Act, which is 6 years from the date of the incident. Now, I note that it's definitely not more than 6 years from today, so this Limitation Act issue is really not so much a concern for now, possibly down the road, but it's just something to take note of when it comes to filing claims. The main thing to note when it comes to tags is that you cannot simultaneously file a claim in tags and also a claim in civil courts, not industrial court, but civil. And this is important to note because when it comes to tags and the civil courts, so if you file a claim for the sexual harassment as well as a claim in tags, they're essentially seeking similar reliefs in the sense that you are seeking damages against the alleged sexual harasser. And because of that, you can only claim in one or the other and not both. So tags is usually composed of a president, a deputy president, and members with legal standing or practical experience relating to sexual harassment. Hearings are closed to the public to protect privacy, but usually victims are allowed to bring along someone who is usually basically there to accompany them. This someone, however, cannot be a lawyer, as parties generally cannot be represented by a lawyer unless there are complex legal issues involved. One thing to note here is that if one party is allowed legal representation, the other party is also automatically granted legal representation. However, so far, we have not heard of any applications to be legally represented being granted. So that's just something to take note of. But however, even though lawyers cannot represent you during tax proceeding, lawyers are allowed to assist you with the drafting of your claim or drafting of written submissions. Yeah. So as I said earlier, the entire thought process behind tags is to ensure that it's highly accessible and it's not costly for the complainants to file. So it's a very minimal filing fee of 30 ringgit. Form 1 is then served on the respondent or the alleged harasser within 14 days. And then the respondent then gets a chance to file their statement of defense. And what's important to note is that filing can be done online as well. The tribunal aims to make its award within 60 days from the first date of hearing. And this is actually a very expedient timeline because, like I said, sometimes when it comes to filing claims in the civil court, it can take up to years. In terms of what complainants can get from tags, the tribunal can award compensation or damages up to 250,000 ringgit. It can order the respondent to issue a statement of apology. This can be private or published. When we talk about published, we talk about newspapers, social media, usually social media and other public forums. And it can also order parties to attend any specific program or counseling. So in terms of sexual harassment counseling, so these are all awards that can be given by the tribunal. So an award from tags, even though tags is not considered a court and it is a tribunal, it is final and binding, and failure to comply with the award is a criminal offense under Section 21 of ASHA, and a police report can be lodged by the complainant. When I say an award is final and binding, I don't mean that it cannot be challenged or appealed against. What I mean is that unless you file an appeal, it remains standing. And in this case, it can be challenged by way of judicial review at the High Court on grounds of serious irregularity. And recently, we've seen a case in 2026, the case of A and B. It is an award that was challenged by way of judicial review. The award was challenged by the alleged sexual harasser. And in that case, what happened was the complainant filed a complaint at tags because alleged sexual harasser had uploaded nude pictures of the complainant on various social media websites, and essentially the tags had allowed her claim and ordered for the alleged sexual harasser to make a statement of apology as well as attend counseling. So in this case, the alleged sexual harasser filed a challenge by way of judicial review. However, judicial review application was dismissed, and this was in 2020. So that brings me to the end of my segment. We will now proceed to the Q&A session.
Yes, so it's indeed insightful. We have some questions here. There is a question from Yuna Chia, which says, "Hi, good afternoon. Can you please give some examples of psychological harassment?" Who will answer this question?
Hi, Joseph. I will take this.
Yeah.
Okay, examples can include repeated social invitations, relentless proposals for dates or physical intimacy.
I see. So these things also constitute psychological harassment, huh?
Yes.
All right, thanks. There's a question from Nick Mohammed Zul, and the question is this: if there is no witness and CCTV, how do we charge the accused? And I suppose accused here means the person who we allege the wrongdoing to be done.
Okay, I will be taking this one to Joseph. If there are no witness and no CCTV recordings and whatnot, so it is still possible for a person to be investigated and in some cases also charged for sexual harassment at work. Because many of these incidents, they tend to occur in private. So some of the evidence can come from other sources such as perhaps the complainant's testimony and detailed statement, messages, emails, chat logs, or social media communications, or reports that were made to supervisors, the HR, probably colleagues, friends, or family shortly after the incident, records showing a pattern of similar behavior towards others, attendance records or workplace data, location records, and all that, medical or psychological records, depending on the circumstances. Thank you.
Thank you. That's a great answer. The next question comes from an anonymous. The question is for tort damages. How do we prove damages without a medical report?
So when it comes to claims of tort for sexual harassment, you can still bring a claim for tort of sexual harassment without medical reports, but the chances, or rather the damages that you will get, will be significantly lesser compared to than if you had the medical report. The reason being, when it comes to tort of sexual harassment, a main component of it is the mental pain and anguish suffered by the victim. And even though you don't have a medical report, depending on the severity of the sexual harassment, you can still bring your claim. It's just that it will be much more supported in your claim if you do have that medical report. And one thing to note is that whilst when it comes to the tort of sexual harassment, it's better if you do have the report. When it comes to tags, there is no such requirement. You are filing your documents and everything, but the evidentiary requirement is not as high compared to a claim for tort of sexual harassment. Yeah.
All right. Since we're on the question of proving damages, is there any monetary jurisdiction limit for tags? It's also asked by an anonymous attendee.
Yeah. So when it comes to tax, the maximum award sum that can be issued by the tribunal is up to 250,000 ringgit. So nothing more than that. And that is provided for under the Act.
Okay, we have a question now from an anonymous attendee. And the question is, what if sexual harassment is caused by a stranger? No name or IC or the harasser, just a video of the harassment, for example. I suppose you make a police report instead of...
I think in that situation, it would be best to file a police report. So for example, if you are in a public forum, or if you are on public transport, for example, right? The best thing to do would be to file a police report. And why this would be good to do is because the police can then conduct their investigations. And as a result of that investigation, you could potentially identify who the alleged sexual harasser is. Because for claims in tags, you do need to know who the actual respondent is. It cannot just be an anonymous individual, right? You need to actually name the person because they need to come in and put in their defense and their position. So the best way to go about it, as Joseph suggested, would be to file a police report. And then if the police can identify the alleged harasser, then you can take things from there and file a complaint in tags.
Thanks, Kirthika. I think we have a last question here, a question from Judy Gan. What are the advantages and disadvantages of filing a case in tags instead of the civil courts?
So I think in terms of advantages, tags is obviously a lot faster because, like I said, the tribunal usually aims to get your award out within 60 days from the date of the first hearing. It's a lot cheaper because the filing fee is only 30 ringgit. The tribunal still has powers to issue subpoenas to compel attendance of witnesses. So it has similar powers in respect of the court in terms of compelling witnesses to attend. And it's also a lot more expedient. In terms of disadvantages, obviously when it comes to claims for tort, your monetary limit, there's no really limit when it comes to claims under tort. So you could potentially get more than 250,000 in damages. But again, that sort of needs to be offset with the cost of litigation in civil courts, which can get quite up there, especially for complex claims and if it involves a lot of evidence and medical reports and things like that. So those are just roughly the advantages and disadvantages.
All right. So thank you so much for the explanation and the answers to the questions. So before we end, I have a few announcements to make that will be here. First, please join us again for our upcoming talk on the 2nd of July 6th. That'll be a Wednesday. The topic will be dating others before divorce. Legal risks for custody, maintenance, and assets, for those of you considering. And we have a feedback form that will be sent in the chat, I believe. Please fill in your feedback in the feedback form and tell us what you think of our talk today. The link for the form is posted in the chat. Thirdly, please follow our social media accounts. And fourthly, after today's talk, if you would like to speak with our lawyers, we offer a complimentary consultation of up to 30 minutes over the telephone or via video conference. Please fill in the form on our website. The link is also posted in the chat below. So to our guests, thank you so much for joining us. We hope you have found today's session informative and useful. Thank you to our two brilliant speakers as well. Thank you, everybody, and we will see you at our next talk.